You joined us today. You are in for an amazing few minutes with this beautiful guest that I'm having today. My name's Kelly Bulkowski, and what we do is we try to give women nuggets of information that can help empower them to be the best person they can be and the best themselves they can be. Not to be the best person, because we all strive for that. We have to be the best us we can be. And by empowering us to do that, we are given the fuel to get there. So, with that in mind, a little bit about myself. I started doing this because I did not come from a silver spoon situation. Anyone who knows my story knows a little bit that I came from a situation of desperation. I came from a situation of trying to rise myself out of ashes I had an ex-husband a husband at the time who, if he had $1 in his pocket, spent two. We had credit card debt. We had just overwhelming devastation. I tell the story of taking a walk one day and finding a $20 bill and sobbing because I realized that $20 could save me, but that meant it could also break me. So my goal is to help other women who might be in that situation rise up out of it faster than what I did and give them some of the information that I've learned. And that's why I love to bring women who have also done amazing jobs with rising up and becoming successful in their fields. And that's why Miss Jessica is here today. Jessica is an attorney here in Florida, and I am going to turn it over to you, Jessica. Share a little bit about yourself. Give us a idea of who you are, what you do, and maybe why you do it.
Okay, thank you, Kelly. Good morning, everyone. My name is Jessica Lynn Silva, and as Kelly mentioned, I am an attorney at law and also a mediator. And on the side, when law gets to be a little much, I'm also a voiceover artist. So you always have to find that balance of your day job and then something that interests you, that brings you joy and peace. I am lucky enough that all of it brings me joy and peace because I'm advocating for my clients and helping them understand the realms that can be quite confusing at times. Kelly, thank you so much for sharing a bit of your story. I love transparency because sometimes we meet someone and we think, wow, they look so polished and put together, and they're not. I personally grew up poor. My family's awesome, but we had no air conditioning in our house growing up, and people gave us their cars because they felt sorry for us. So, and now today I have 4 college degrees, been happily married for many, many years, 3 children. My children are currently 26, 21, and 17. I have one granddaughter that's 1, and I have a second granddaughter about to be born. So my life is full and I balance it the best that I can. And then one of my favorite things to do is what I'm doing this morning, where I just share wisdom and knowledge. No expectations, just wanting to share things that could change and pivot your life if you knew. So I have been in the legal industry over 20 years. I've been in a variety of fields. I was a paralegal. Then I worked for a judge for 4 years, and then I've also been an attorney. So I've seen it from several different perspectives, which I think is awesome because then once you are the boss, you remember what it was like to not be the boss, and you remember those key points and all of those type. Attorneys, we always know, I say, just enough to be dangerous in lots of fields, but a lot of us will start to niche. And my niche is estate planning and probate. So that is what I deal with on a day in and day out basis. A lot of people ask, what is estate planning and probate? Estate planning is setting you up for success. That's the shortest way I like to say it. If you are alive and competent, you have full control to say who you want to speak on your behalf if something happens, if you're incapacitated or if you pass. And then when you pass, you are able to say where all your hard-earned assets are going to go, or who you want to raise your children, or who you want to be these key decision makers. So it is actually very easy and very cost-effective to do now. It is very chaotic and very expensive and causes lots of family turmoil when you just don't do anything and think it'll all work itself out. It does not most of the time. And I have seen disastrous results, lots of true stories, enough that it's made me feel my time is very well spent to just educate everyone that wants to listen. So did you have any particular questions for me, Kelly?
Oh, I have so many questions
Okay.
and so many things that I want to go over today. But I love what you just said because it's so true. A lot of people get confused, and I always say confusion leads to nothing. A
Yes.
confused mind does not move forward. So when people don't know what to do, a lot of times they'll regroup, and that
Mhm.
means nothing.
You
So
freeze and you stay frozen because you feel like, and then you never take that next step because you're waiting for all the stars to align before you take that next step. And that's just not reality. It
no.
very rarely do all the stars align.
Right. And that's exactly why the women who have joined us today are going to have that next step of knowledge, and they're not going to feel that frozen status because they're going to have at least a little bit of more education after they leave than what they did when they
Mhm.
joined us. At least.
That's my hope.
So the whole purpose again of our conversation today is what happens to your money after death, and how do you actually have a conscious say and feel for what is going to happen to that money. So with that being said, let's just kind of jump in here.
Mhm.
um, Obviously, we've got Miss Jessica here, and as I said, attorney at law. I just want everyone to understand that she's coming to you with a giving heart and with a head and heart full of knowledge that she can share. So please, if you have questions, we
Please.
want to hear them. We want to go through some of the questions that we've prepared, share those questions that you have, because those are real life questions and we want to jump into them as well. So, starting off today, we want to debunk some of the largest misconceptions that people have regarding estate planning. And I think, Jessica, one of the first things that people say to me is, oh, I'm not rich, so I don't have an estate to
Mhm.
plan.
Yes, I hear that a lot. The reality is everyone has assets, even a homeless person, and you have control of to say where those assets go. And actually, the less value of your assets, the more important and crucial it is to have planned, because then you're not having to involve the courts and attorneys and creditors and issues, so that that small little pocket goes to who you love and doesn't get squandered with all of the other pieces. So I would say the less value, the even more crucial. And then, of course, you have your extremely high value, and then they have a whole different arena of why they need to take certain precautions for certain reasons. But there is, in my opinion, once you are 18, you should have an estate plan. You should have power of attorneys that say, if I was to go skiing in Colorado, slip, while I'm in a coma, here's who I want to be my voice. Here's who allowed to speak on my behalf, whether that's my financial choices, my homes, a business I run, a buying, selling a property I was about to do. And then there's also the medical power of attorney called a healthcare surrogate, where that is who's allowed to talk to doctors, who's allowed to get through HIPAA, who's allowed to authorize a surgery. All of that is very easy and seamless if you have the proper documentation. It gets very convoluted, very complicated, and if there's multiple people trying to fight for certain rights, it can get very, or the circumstance, if you don't already have them, there is no time now to do it, and so everything's frozen. You will lose those deals. You will lose that house you were supposed to do, and I have seen that personally happen. And then you only have two choices. You wait to pass, or you wait to come out of your coma. So that is where just that's dealing with the fact of why you're alive but incapacitated. Once you pass, then we're dealing with a whole nother set of issues of who's going to be the spokesperson, who's going to gather up all your wealth, who's going to transfer that wealth and assets. Where is it going? Is if you didn't leave a will or a trust behind, the courts assume, okay, well, you didn't leave us any game plan, so we're just going to go under the intestacy law and we'll just assume you were besties with all your family members. We'll go down the family tree, we'll find the first that fits under the law, and they're going to get it. That could have been exactly be like, oh, no biggie, that's who I wanted. Or it could have been, no, that's the last person I wanted.
Right.
Judges want to help you. So if you leave them documentation, and I always say my goal at my consultations is you tell me, we go over your assets, we go over your wishes, we go over who's important to you, who you do not like, who you don't want involved. And then my job is to make all of that into legal enforceable documents so that I make it quick and painless when the time arises. So it's just like anything, it's preparation. It's preparation for the unknown. It's not scary. I hear that a lot where I don't want to think about it. Or if I think about it or do this, now I'm going to accelerate it. No, you're not. You are actually will be so much more rested and peace of mind. And a lot of my clients, when they leave, they're like, oh, that wasn't so hard. And you made it so quick and painless. And now I can sleep tonight. So I love that feedback. And we hear it
Oh,
quite often.
yeah. Isn't that true? I know I've had people say to me, they didn't want to think about life insurance because they were afraid karma. If they
Yes.
thought about it, it would rush it. And it's like,
Nope.
it doesn't, but that peace of mind of knowing, okay, check this off my list. You get auto insurance and you don't think, oh, I can't buy auto insurance because that'll mean I have a wreck. But for some reason, when we start talking about death, people get very, very concerned. Very
You
scared.
don't get flood insurance on your house and all of a sudden think you're going to have a flood in the next hurricane. You just do it as a precaution. You were made a smart adult decision and then you don't think about it. So that if the occasion arises, you're like, oh my gosh, I was my own best friend. I was my own best advocate and I set myself up for success.
Right.
That is the key.
Now, let's kind of, you unloaded so much valuable information there about the different forms and everything that's part of an estate, because everybody just automatically thinks of will. But let's back up one step. So I think a lot of people just naturally assume, well, if something happens to me, everything naturally goes to my spouse.
No, that's not always the case. So what happens is in 2023 and all of this and in recent years, blended marriages are very, very popular. And in blended marriages, if you have not, in Florida, if your children are 18, then you can leave them or not leave to them. That's totally your choice. If they're under 18, you are statutory required to leave them something. Spouse, they have certain homestead rights and certain rights to certain assets unless they have waived those rights in a prenup and a postnup, which I encountered those type situations as well. But if you say you had children, you were married, you had 3 adult children from a previous marriage, then that doesn't last via divorce or death, and then you remarry, that remarried spouse does not automatically have assets, all of your assets. She will actually, if you leave us no will or trust or game plan, then under the intestacy law, your spouse will get half and your kids get half. So that causes a whole bunch of domino effects and issues that people did not expect and do not like. And I see it all the time on a daily basis. It is very easy to enforce the legal documents we've prepared when they're all nice and situated. It is very hard to do damage control and be fighting against the law and trying to just minimize what's happened and what we put into place. And it always breaks my heart when I'm dealing with situations and I'm like, if they had just done one thing different, they wouldn't even need me. They wouldn't need me. They wouldn't need probate. They wouldn't need court. Wouldn't be fighting creditors. Like it literally would have just seamlessly passed to who they want. So your goals when you have an estate plan is to say who you want to be your voice. And then the goal is to avoid probate and protect yourself from creditors. So those and for everything to seamlessly go where you want. That is what your goals are. So some of my older clients, I'm not sure if you're familiar, but in Florida, we have something called a ladybird deed. So 5 states allow it. Florida's one. It's pretty much naming a beneficiary for your real estate property if you owned a homestead in Florida, because your homestead is protected from creditors. So a lot of times my older clients, they don't have to necessarily jump to a trust. And that's the point of our consultation, is to get a feel of what do you own. I don't want to know what you own because I'm going to change my fee. That's not changing. I want to know what you own so I can tell you strategic advice to avoid probate and minimize the creditors and do it legally and simply and get everything to your loved ones. And I always joke and tell my clients, when I have you now, I try to set you up where you don't need me later. So that's really what my goal is to do. Some situations that can be done by simply naming payable on death beneficiaries on your checking, savings, investments, and life insurance. On investments and life insurance is called a TOD, transfer on death. It's the same thing as the POD, but it's just interchangeable, kind of like personal representative executor. They're the same, but different states call them the different terminology. So I get a lot of confusion in those regards. If you're not a candidate that can simply do that by naming beneficiaries and putting a ladybird deed, and that doesn't solve the issues, then we move into discussing trust. I personally go into distrust discussion if you have minor children, if you have special needs children, spendthrift, you own multiple properties, or you own property across state lines, or blended families with a lot of caveats in place. Then we're in trust territory. They're already worth it. They're already going to be priceless. They have so many benefits. But if you're not in any of those categories, we're not going to jump there. So those are kind of things that, again, conversation, communication, knowing what your options are, what your goals are, all of that is what takes place.
So what about, and I've actually had a couple older people tell me this,
Mhm.
not putting anybody in brackets, but they think, okay, this is how we used to do it. What about that person who's written down their wishes and they say, I had it notarized, so I'm good?
In Florida, your will has to be signed in the presence of 2 witnesses and a notary, and they have to be 3 separate individuals, and the notary cannot be related like a spouse or a children to the witnesses. So there's caveats that have to be in place for
But
it to all be legally sufficient.
would that even work though? I mean, that's going to hold up for them.
And 2 witnesses and a notary.
Mm-hmm.
If you have a last will and testament and it's specified and is signed in the presence of 2 witnesses and a notary, then technically it follows the statute requirements. However, what happens a lot in the do-it-yourselfers is they
Yeah.
forget to include a residuary clause. They forget to name who the personal representative is supposed to be. They forget to name like certain specifics. So it's really more vague and confusing than it is actually helpful.
Gotcha. It's kind of like giving that roadmap, but then it got wet, so you can't really see all the lines or see exactly where you're supposed to go. But
Or the trustee'll, I don't want to leave anything to this certain child, so I'm going to leave him $1.
yeah,
Well, leaving him $1 just made him a beneficiary. Now he's entitled to all of the process, all the documentation, all the everything. So yes, Johnny will be very pissed off to find out Sally got $1 million and he gets $1. So that's like just pouring salt in the wound. And the wiser way is to say, I have 2 children. Their names are, I am intentionally not providing for. And that is where it's very clear. So it avoids the will litigation of mom would never have left me out. She loved me dearly. There's a mistake. Either my mom made a mistake, the attorney made a mistake. Like that's where. So there's just little nuances that make sure that it's important. And then including a proof of will, because if you don't have a proof of will, the 2 instant notary stating I'm mentally competent, I'm alert, I'm doing this of my own free will, I don't have a gun to my head, then you have to go track down witnesses and get sworn affidavits that they were present and it was then they were doing it willingly. Nobody was trying to hold. So there's just different. And so in those situations, when it's been prepared by an attorney, it gives it a lot more teeth and the judges feel a lot more comfortable because they see a reputable attorney prepared this, there's something going on, they're willing to do a sworn affidavit. So it kind of helps versus not knowing, did mom really write this or her daughter did and pretended and forged her signature and got 2 friends to pretend to be witnesses. So
yeah, it almost sounds like all the horror stories, or a lot of the horror stories that you hear, are because people maybe tried to do it themselves or jump through some type of hoop that really was not. If they would have had a professional like yourself assist them with it, there would have never been an issue.
The couple other things I always see with the do-it-yourself that causes trauma is they know mom's dying and they're named power of attorney. So they'll run out and quit claim deed houses to themselves, being like, mom wanted me to have the house. And Florida won't honor that. So when you try to sell or refinance the title company, they'll void it. Like they'll never consider it as an actual valid transfer. The other one that is an issue is the do-it-yourself quitclaim deeds. And what happens is your quitclaim deed or warranty deed or whatever, ladybird deed, whatever you're doing, it must exactly match legal description, and the way you took title is the way you need to sign as grantor. Those type things will make it, the clerk's office will accept whatever you give them. So they'll accept it, assign it a book and page, and then it makes its way to the property appraiser. The property appraiser will thoroughly review it, and if it's not sufficient, it'll never make it on the record. So people will do it yourself, go file with the clerk and call it a day, and 5 years later realize, oh, that never actually showed up on the record. It was never valid. crap. So it reverted back the old way. So it never actually changed hands. And so that causes different issues. So they think they're trying to move things along and be productive, but they don't know what they're doing. And so they don't realize they actually caused more issues. And it actually would have been so more cost effective just get it done right with an attorney versus what the trying to fix it is now going to cost.
Okay. Now, since we just talked about the ladybird, I had someone ask, do you know if New York is one of those other 5 states that recognizes that?
They're not, I wish, but no, New York is not, Georgia is not, North Carolina is not, New Jersey. If you Google, there are 5 states. I know all of Florida law. Well, not the same. I know the Florida law in my niches, but I do not go out there and study the law of any other state. So I mostly know about those because I have a lot of clients that own in Florida and own in the Blue Ridge Mountains, own in Florida and own in North Carolina mountains. Ones that do, Colorado has transfer on death ladybird deeds. So what happens is 5 states allow ladybird deed. Florida is one of them. 24 states allow transfer on death deed. That's kind of a version similar. It's a deed that you do in the clerk's office. It says, if I pass, here's who can have it. So some states allow that. The rest of the states, they don't allow either. So there, your choices are pay for probate, which you never want to do because that's the most expensive and involves the creditors and the courts and the hearings and the attorneys, or you pay for a trust. So when I have a client come to me and they're like, yeah, I own 2 homes in Florida and I own 2 in Georgia, we're already in trust territory. Like it's already worth it. It's going to already save them. Because the other key factor to remember is when you do need to probate is bringing your will to life. It was not created for you or your loved ones. It was created for creditors. It's their last ditch effort to attach to your assets while they're on the way to the beneficiaries. So that is why you always hear the word on the street of it's expensive, it's time consuming, creditors get it all, the beneficiaries ended up with nothing. That's where those realms come from. It's not always that drastic and horrible, but it's enough of a teeth that it makes people avoid it. So in those regards, that is where trust become a vehicle that just have a lot of advantageous and they're worth it. One of the keys is because if you live in Florida and this is your primary place of residence, then Florida is where you would open your primary probate. But then you have to go open what's called an ancillary probate in every other state you own real estate. Some people, that's nowhere. They're just Florida. They have their one home. For other people, they own lots of states, or they were military and everywhere they got an assignment, they bought a house. And now at the end of their retirement, they have 12, 14 houses all over the state. That would get insanely expensive very quickly, paying for attorneys in all those states to handle the probates. So that is where a trust will have paid for itself 100 times over, because what happens is you can create your Florida trust and then you put all your properties across wherever states, wherever they're located, into your Florida trust. So then you can just remove them from trust, your successor trustee would, upon your passing, and they'll give them out to the beneficiaries. So it makes it much, and you are in control. Your successor trustee is so they don't need the court's involvement. And in Florida, if you're doing a trust administration, you can actually do it yourself or retain an attorney. So you have an option. I usually go over with my clients and I tell them, I'm like, here's my fee to do it. You're welcome to do it yourself. And most of the time, the fee is so reasonable. They're just like, could you just do it? Because I have no idea where to even begin. And it is worth it to me to just know it's done and done right. And I don't even have to think about this.
Okay. And then another question on the ladybird. You've obviously hit a note. Someone's very fascinated with the ladybird. If you have a rental property in an LLC, can that be passed via a ladybird deed in Florida?
The ladybird deeds, no, the homestead can also not be. So when you start getting an LLCs, the point of an LLC is supposed to be a limited liability corporation. It puts a little moat around you, and the goal is to try to protect it from creditors. The thing with LLCs is there has to be a member manager of the LLC. That's typically a person. Florida's come under hot water for one member LLCs where there's been a lot of court that's not held up, that's actually been in the favor. So I always recommend you talk to a corporate attorney, someone just to discuss if it's even worth it. When you put it into an LLC, a lot of times my clients that are going to go that route, we still have created a trust, because then the trust becomes the member manager of the LLC, which allows you to skip the probate process. So that is why it's super important, because if you have an LLC and your own name is the member manager, one, under the current back and forth that's been going on, you're a little more vulnerable anyway. And then two, if it's in your name as the member manager, it's now an estate asset of yours. So the only way it's going to get where it's got to go is probate, unless you put your trust as the member manager. So there's different caveats and things like that to consider. Some also, when you have an LLC, you always want to be careful that you don't pierce the corporate veil. So that's where someone just tries to accuse you and say it's a sham. You just tried to do it to avoid liability. And then we're going to say all the ways that you really aren't actually treating this as an authentic business. So in those regards, you always want to be very careful that it has its own checking account, that any of your rental agreements all have the LLC as the landlord, like you need to carry. You never want to commingle funds. So some of my clients will own like 10, 11 properties, and you have to file your annual minutes. Otherwise, your LLC will go away. It's got a hefty $400 fine if you're late. And then if you still don't pay it, they'll dissolve it. So then your property is owned by a business that doesn't even exist anymore, because the Sunbiz dissolved it because you forgot to do your annual minute, your report each year. So some of my clients are like, I am not doing that for 10 or 11 homes. And I just want you to create me a trust. I'm going to put in trust. I'm going to get an umbrella insurance policy and call it a day. So that's good, because you always have to look at the caution too. If you had 10 homes and you put them all under one LLC, the point is, if somebody slips and falls on one of those properties and sues and the LLC was found liable, they can go after all the assets within the LLC. So you don't want 10 homes sitting in there, because then you just made them all vulnerable. So a lot of times people will do a separate LLC for each home, which is where it gets very expensive and time consuming and upkeep and things like that.
So it sounds like that would definitely be a situation where you'd want to bring in a professional and examine where they're at specifically, and put together a plan that best meets their specific needs and what they want to do to protect everything.
Talk to a corporate attorney too, and just ask them, go over the pros and cons and what your vision is and the why. So many people, I'll hear it all the time, they'll just be on Facebook Googling and they're like, hey, I'm going to create an LLC. Where do I go again? Is it Sunbiz? Like, they have zero idea. And then I literally encountered a client who had created one before me and then never renewed for 3 years. So I'm like, it doesn't exist anymore, because you never redid it, and then you went past the late fee. Like, so those are just the kind of scenarios. If you're going to do it, you need to be informed and know why you're doing it and how to do it properly. Otherwise, they just feed off of words that they hear and they don't understand the concepts. So, and it's a lot of attorneys, like anything, there are excellent ones out there and ones that genuinely care about people and want to share our knowledge. And then there's, of course, others that are just, they're a little more demeaning or hard to get a hold of. I hear all the stories, but you are always welcome. I personally, my firm does estate planning and probate, but I have connections with many attorneys that are in PI, personal injury, real estate, corporate law, all those. So you are always willing to just reach out to our office. And if we don't handle it, we're happy to give you a name if we have one of someone that you could call. So
great information, Jessica. Thank you so much. And hopefully that answers, or at least gives food for thought on the Ladybird deed, because that's a lot of good stuff for people who have that situation. And then the LLC, wow, I learned a lot myself right there. Let's jump back into, though, you've already mentioned something, and I just want to kind of drive it home. One of the things is people say, well, I did my will, it's good. And I think from what we've talked about so far, every time a life event changes, you really need to go back and reevaluate, is the will still match all your wants, needs, and desires from when you planned it? And I mean, I know just personally, when my mom passed away and then my dad passed away, between my mom and dad passing, they had wrote their will, well, it had been decades. I mean, they had bought their house, did their will, and it was supposed to transition from my mom to my dad. They had equal ownership the way they understood it. So my dad never did anything when my mom passed away. When my dad passed away, we actually had to go back. My mom had passed away 3 years before him, and open an estate for her just for the house. And then we could move forward and do it for my dad. So how often, I mean, typically, if nothing's changed other than just life, you're getting older, how often should you relook at that will and say, wow, just verbiage wise, I need to just make sure everything is up to date?
So 3 to 5 years answers your question that you should take it out and take a peek. Make sure it's still the way you want it. Any kids that have completely disappointed you in life and you need to divert to spendthrift, special needs, cut them out. Any friends, or you don't have family and you have friends and charities you're leaving to, and then something has just, dynamics have changed, or you want those to be shared among more people, not less. Or your power of attorneys, who you wanted to be your spokesperson 5 years ago is not who you want to be your spokesperson today. Because it's very common that I see people come back to me, and once their kids are 18, they want their kids to start being in line to be their spokesperson. So they couldn't as minors, but now that they're 18, they're absolutely welcome to if you want them to. So there's different dynamics. They don't lose their legal value per se. If you lived in Tennessee and moved to Florida, it's called a foreign will. So we're still going to petition the court to try to admit the foreign will, and we have to go and the judge has to approve it and things like that. However, every state has their own requirements on what is considered valid. Like when you had said earlier, is just a notary sufficient? In some states that might be. In Florida, it's not. The other key is power of attorneys is where you'll actually run into a lot of the hiccups, because Florida does not like to accept out-of-state power of attorneys. They want it to be here written under Florida law, and they also don't like when they get super old. It's not that they're not legal, it's that we call it stale. So they get nervous because you're literally using your durable power of attorney to access mom's bank accounts. They get a little skittish, like, hey, from 10 years ago, does mom still want Mary in charge right now? Like, is there a recent one? Is someone's trying to take the money and mom's going to wake up and sue us so they get a little squirmy. So we always, whenever clients move here from out of state, they usually freshen up all their estate plan with me. Or if it's just been so old and we're in there making a change to a will or a trust, I will go ahead and freshen up all their power of attorneys just so they're right now current. When they need to use them, they show they've been done in the past year or two. So it just kind of sets the ease, because it's just still steps for success, because it's not taking much time or money, and it's setting it up for a beautiful thing later. If you don't, all the chaos and confusion, and there's many times I'll get a durable power of attorney and they're like, the bank won't accept it. Can you please write a letter on your letterhead that you've reviewed this and it's legal and they should accept this? And it just causes more issues and confusion. So you can avoid those type things. So that's a lot of what. So 3 to 5 years is where you should take a peek. And then if you've gone through a divorce or death or change, then yes, you just want to reach out. If you love the attorney you worked with, just reach back out to them, but you do not have to. Some people think that who did their will and trust is who they always have to go back to. That's not true. You can go to whoever you like, and even when you pass, your family can use whoever they like across the state. They do not have to use the person who prepared it.
Oh, no, I did not know that one. That's
a lot don't. And so, but no, you are welcome. We can all pick up with whatever you hand us or we track down. So you're fine.
Okay. Now, here's one that when you and I spoke, wow, you really enlightened me on this one. And I thought I understood this one. What's the best way to protect your minor children? And what's the biggest mistake? And from our conversation, you had mentioned the permanent and the temporary. So if you could enlighten on that a little bit, I was blown away with that. I had not thought of it.
Children, the easiest way to do it. So what happens when I'm doing a will package for a client and they have minor children? I will include, it's a will with a testamentary trust, and I will literally put a whole little trust inside the will. So it makes it much longer. And that is dealing with who we want to be guardianship and trustee of our children, are they to be guardianship of the children themselves and also guardianship of the money they're going to inherit, or one or the other, both? You have that choice. So you can tell me now how you want that to be. Some people are very caring and empathetic, but they suck with finances. So they would love your kids and tuck them in at night, but they would bankrupt their wealth before they ever reach 20. So that's kind of where we go over those dynamics. And then the other is, what age do you want your kids to inherit? Technically, once they're 18, they can inherit. They can inherit property, they can inherit wealth, they can inherit it all. But do you want your 18-year-old to have $1 million, $2 million in a home that they have no idea how to pay taxes and insurance? Or do you want the trustee to stay in place until they reach 21, 25, 27, 30? Do you want them to get monthly distributions? Like when they turn, as soon as I pass, they're to get $1,000 a month. And then when they turn 18, make it $5,000 a month. When they turn 21, make it $10,000 a month. We literally can create documents that reflect your wishes. I just need to know your wishes, and then I'll take it from there.
Very good. And then that's huge, because taking care of and managing finances, like you said, some people are great at one, but terrible at the other one.
And then the document you're probably referring to is what we talked about, is the pre-need guardian for minors.
Yes.
And that's where I take it a step further. And that's where it's clearly listed and it can go to guardianship court. That is what saves that if a parent passes, your kids don't spend any time in foster care. The police immediately know Charlie can go with this person, or Charlie can go with this neighbor for until the family member arrives. And then the family member he's going to live with lives out of the country, so he's to stay temporarily here until that person arrives. The courts and the police and everyone, they want to help you, but we're such a litigious society that if there's nothing documenting your wishes, people are skittish and nervous, or their hands are just tied and they're not able to grant what you're trying to. So screaming at them, I know she wanted me to have him, I know she wanted me to have him, does no good. Providing a document of, here's a pre-need guardian for minors stating that I'm to be first in charge, that makes a whole different ballgame.
Well, and when you told me that, when we were talking the other day, it blew my mind, because you automatically assume, because when my kids were little, okay, I know that this is the person who's going to raise my children if something happens to me, but you don't think of that time frame of, okay, it will take them 2 days to get here because they're in another state, in that situation. Who takes them that day, that night, that hour? And they could go into foster care until the person who permanently is going to raise them could be there. So I just thought that was just mind-blowing for me. And maybe I'm the only one who didn't know that, but
oh no, that's common. It's also very common that nowadays people are not choosing family members to raise their kids. They're choosing family, where it's friends that are close like family. They're not in the priority list with the judges if you did not leave a document saying such. Like, they're always going to go through bloodlines or give preference and stuff like that. And the only way to try to knock through all that is everyone get attorneys, everyone fight it out, have court hearings, wait for the judge's docket to open up, and then the judge will use their discretion based on who's the attorney that's most persuasive and evidence supported, and that determines your kid's future. Where, to step it back, if you had done an estate plan, you determine your children's future. Right. So you're in charge.
And it's horrible, the idea of assets being locked up in probate for months, years, but children's fates being locked up for days is devastating compared to, considered.
Well, they're already going through a shock. You
Yeah.
don't want to keep that shock by ripping them from the home they know. They don't have their parents. They're now with strangers. They're confused. They're scared. Like, nobody wants to do that. And all of that can be avoided with the proper documentation, which is and even if you change it, it's not written in stone. And I always tell people, your estate plan, as long as you are mentally competent and alert, you can change as much as you want, all the way up till on your deathbed. As long as you can still tell me the president, the date, you clearly understand what I'm asking you to do, and you can tell me these are your wishes, and I don't have any concerns that you have gone a little cuckoo, or you're so drugged up, or your dementia, then you have the right to change. So it doesn't matter if your handwriting is bad because of a stroke or anything like that. It's the mental capacity that we have to know these are your wishes, and you're doing them not under duress, but of your own free will.
I had someone say with the POA, which that's, again, huge for most people. Would it be better if you have two children, one lives in the state you live, one lives out of the state you live? Would it be better to have the POA with the child that's in the same state as you, or the child who's out of the same state or out of the state?
That's preference, because the one who lives out of state just might be the one you're closer to and has a more stronger maturity factor. So if that's the case, what happens with power of attorneys, and that's a common question I get, is we have choices. You can say, I have 3 children and I want first to serve, second to serve, third to serve, alternates. Or I can say, I have 3 children, I want all 3 to be able to serve, whoever can do it first. And that means I would name all 3 as primary, and I would say any may act independently of the other. That is where I just said it's a free for all. Who's ever most able to get to the hospital, talk to the doctor, get to the bank. The danger in that sometimes is if you're someone a little shaky or there's a lot of opinions, then you can say, I name all 3, must act in majority, must act in consensus. That's where 2 out of 3 will win, or all 3 must all be in agreement. And if all 3 aren't agreeing, nothing's happening. So you have options in regards to that. Location should not be what you're factoring. It should be relationship and trust. Those are the key factors. Location's fine. Even when I'm probating, I have clients out of the country. I never even meet them, because that's not as important as just knowing that the person I named, I trust them explicitly, that if something was to happen to me, they would handle my affairs in the way that I would want them handled.
Yeah. Wow. And that is so important, because you're right. That child that lives out of state might be way better with finances and dealing with pressure, and the one that's here may not. And you don't want to put them in a situation where you're setting them up to fail, basically.
Right. And I do a pre-need guardian for my clients. Not a lot of attorneys do. It's just something, to me, it makes common sense. And I say my pre-need guardian is like a durable power of attorney on steroids. If you got dementia, Alzheimer's, believe the Prince of Persia will make you rich, you're just handing out money to strangers, then these are my preferences. If my child needs to go to, or a friend, whoever it is, wants to go to guardianship court and have this enforced, it's already done. I had one client who kind of put a value on it, and he said, you realize I've already spent $8,000 trying to fight and I'm still not done. We would have had no need for it if I had had this from the other person we had used. So that kind of showed me the key, because we all know as you age, and everyone does this, the older and older we get, we either become too trusting and we trust everyone and you literally get conned and you hand out your money to strangers, or you trust no one, including your family members who have your best interest at heart, but you're so scared you don't even trust them. And so this is a document that kind of just takes all the dynamics, the family dynamics, the arguing, the stress, the chaoticness, and just kind of has it. It's just there. It's the document you hope you never use, but it's priceless if you need to.
Which brings us to a kind of wrapping up in some of our later points here, or wrap up points. An estate, which is kind of how we started, estate planning is way more than just a will.
Very much. You actually want to your will is really just a backup, that if you own a vehicle, they take it to the DMV, show the death certificate, and have the car transferred because there's no lien on it, or you die under suspicious circumstances. So a huge windfall is coming through the estate that you didn't have today, so you didn't have a chance to go put it in checking or an investment and name a beneficiary. It's coming through because of your death, or because of someone else passed and left you an inheritance and you didn't know about it yet and you've since died. That is where it's there, almost like a backup.
Right.
You honestly want to set up things with beneficiaries, or you want to have trust. You want to avoid probate if at all possible.
Right. And that's what I preach all the time with the products that I work with people on, is naming those beneficiaries, having a contingent beneficiary, making sure that they're protected so it does avoid probate, goes directly. But there's one other point or paper that I want to really mention too, because I don't think a lot of people know about these as well. The do not resuscitate and the living wills, and how they can tear a family apart as well. Because if you have definite wishes on these things, you need these forms in place, because as you and I had spoken, it can completely divide a family. So could you tell us a little about those?
Yes. So living will, the best way people recognize it is the Terry Schiavo. Terry Schiavo became the big national phenomenon where husband wanted to pull the plug, parents did not, and it became an entire court fight and process, and it was horrible. And it just dragged off and diminished. Nobody knew what Terry wanted because she didn't have a living will. Otherwise, it would have been a clear cut, just enforce her wishes, no more barns about it. And so that is where it just gained a lot of traction. Living will is where you literally state at what point did you want your family to pull the plug. You live in America, so you have the freedom to make your choices. So you can sign this. I always say they're a roadmap for your healthcare surrogate to know your wishes. So, and when you go to that surgery and doctor's appointment where they always ask you, I always say show them the healthcare surrogate because they need to know who they're allowed to speak to. Don't always show them the living will. Just they'll ask you if you have one. Just say yes. Pull it out when you need it to be enforced and when you need it to back up what you're asking the doctors to do. But until then, let them fight for you. Let them do everything they need to. But in the back of it, it'll save the family dynamics because when that time comes, when the family member's being asked, they'll know your wishes. So they're not in agony trying to decide. This one's personal to me because my dad did not have one because that was a conversation. He talked about other things and set himself up for success, but he didn't want to talk about that. So every time I'd bring it up, they'd be like, let's play games, Jesse. We'll talk about that another day, which I preface that with, I don't do my parents' estate planning because you don't do family members, but we still have conversations. And that was a conversation they didn't have. So when my mom and I were getting bombarded with 3 doctors telling us we were cruelly keeping my dad, he was in a coma and he was suffering, and they laid the guilt on you so huge. It was agony. And I have 3 brothers, and everyone had a different opinion. So to this day, it has caused conflict in the family personally because everyone had their own interpretation of what dad would have wanted, but no one clearly knew what dad wanted because we didn't have that document. And so those are kind of the situations where it causes damage it otherwise didn't have to. So it's just another step for success that if you have it, it's simple. If you don't, it causes chaos.
Well, I appreciate you sharing that. And I know it was personal, but I really think it was a strong story for people to hear because even when you know the answers and you know the questions that should be asked, sometimes people just don't want to have that conversation. And as painful as it is for you, they really don't realize their lack of addressing it caused family pain later. And I mean, no parent wants to put their child through that or division of their family. If he would have known that could happen, I'm sure he would have had that conversation. But it's easy to reflect back and say, wow, I wish I would have done something differently because now I have more knowledge. So maybe you can with that story, save another family from having to go through that. That is very helpful. Good. So Jessica, oh my gosh, I can't thank you enough. So much great information. Do we have any other questions other than what we've already addressed? Let's see. I'm trying to see if we have anything else out there.
Not a problem. Anyone from today, if they did have questions, I would wait the free consults for anyone that would attended your webinar this morning. So they're welcome to reach out and just speak with me one-on-one privately for an hour. And I'm happy to go over things with them. No pressure, it doesn't cost you anything but your time. And I have offices in Satellite Beach and Tampa. And then I also offer Zoom and telephonic. Like as soon as I'm off of this at noon in 10 minutes, I'm going on a Zoom new client call. So I work very quickly. So whatever works for my clients. So I can handle the whole state of Florida. Okay. So I have clients out in Destin, Miami, all over the place.
I have a question here. Someone wanted to know, are you able to create a trust when your house is still under a mortgage and a balance?
Oh, yes, absolutely. Yes. And also on that, your home, you always get 100% homestead across the nation. Florida has homestead. Some states don't, which sad, but Florida does. And we're one of the most protective of homestead, which means it's exempt from creditors because we don't want everyone sued and ending up homeless. So in that, you can put your home into a revocable living trust, and you can do a ladybird deed for it if it would benefit you, and it does not affect your homestead. So you are safe there. You are fine. If you put it into an irrevocable trust or an LLC, you cannot have homestead. So, but it doesn't matter if there's a mortgage. What they're probably referring to is when people put homes in LLCs. If you had a mortgage on that property, technically under the law, they could trigger the acceleration clause, the mortgage company. Tons of real estate investors just play the game and hope they never do. But it legally they could. They just don't tend to enforce it. And if they did, they usually send you a letter saying, hey, you removed this from your name. You need to get it back within 30 days or we're going to do your acceleration. But that is for irrevocable trusts and LLCs. Revocable living trusts and ladybird deeds, they're fine. They do not affect your homestead.
Perfect. Perfect. Absolutely wonderful. So what we do, and we have a free gift available to everyone. And what we're going to start with, so we can kind of get some organization and know where we're at with all these things. We have a free gift that is going to be an empowerment audit. And we're going to go through and answer some of these questions so you kind of get an idea of where do I stand? What do I need? And then we'll go ahead and give you Jessica's information so that when you actually talk to her, you're a little more prepared and know what do I need to talk to her about and what direction might I want to go with everything, because she has fantastic knowledge and she has packages and she's done all the hard work. She's done the homework for you. We just have to figure out where you're at. And that's what we're going to do with our estate empowerment audit. We're going to figure out where you're at, give you a point system so that you can kind of see areas that you might need her help with. And then you can actually make that call and talk to her. And she has so generously said that if you're coming from this webinar, she's going to give you that consultation. So, wow, what a fantastic gift. Jessica, thank you so much for that and all the knowledge. And I'm trying to see if any other questions have come in. Just fantastic comments, fabulous information. Thank you so much. Yeah. You're awesome, which we already knew that.
Oh, thank you. You guys, so are you, Kelly. Like I enjoy this because to me, this is the way you give back to the community, because you take your time and knowledge and effort and you give. And so you can go over how the way you take title, the way you have a document, the way you do changes the whole dynamic of what will go on in your personal scenario. So I love being able to break through any barriers where you think attorneys are stodgy and expensive and bill you for every second. I like to break through that and show, nope, we're actually approachable. Some of us, we're very approachable. We still have knowledge and we treat you with kindness and respect, and happy to do so.
Yep. And like we talked before you all joined us, Jessica and I were talking, and our biggest hurdle a lot of times is a confused mind does not move forward. So Correct. People think I should do something on this, but I don't know what. So they do nothing. And then time goes by so quickly that they've done nothing, that it's forgotten until now is the day that they wish something would have been done. And that's why we wanted to start with giving this 20-point estate empowerment audit. So now when you talk to Jessica, it's not as confusing. You kind of have a grasp of where you're at. And when you talk to her, you can say, okay, I realized I don't have everything together. These are the areas that I'm short on. Can you help? So, all right, Jessica, thank you so much. Thank you so much.
You're welcome.
Everyone for joining today, and be empowered and be the best you can be. We thank you for joining us. Have a great day.